Alright guys, welcome back. Today I've been working on my case. I gotta do a response to a report and recommendation from the federal magistrate in my case. I'm still working out what makes the legal industry, being the attorneys, the judges, the lawmakers, the clerks, the paralegals, to all believe the things that they believe. So that's why I bought, uh, you know, I went on the college textbook registries for what books you have to buy to go to the legal courses that the major five legal schools here in Michigan have. That would be the University of Michigan, Michigan State University, Cooley Law School here in Lansing, Wayne, I want to say Wayne State over in Detroit, and also Detroit Mercy, also in Detroit. Seem to be the five major law schools in Michigan, and I think there's one more that it doesn't matter. Those are the major ones, anyways. But they all have textbooks when you go onto the classes, like you're actually studying for a degree, and they let you know like what books you need to buy, and you can rent them from Amazon. This is administrative law. Oh, I'm sorry, this is the federal court book, so probably just practices or famous cases and stuff like that. Um, yeah, you can rent them from Prime and lease them until you buy them, or you could just buy them brand new. I have one that was brand new, and that's my property law book. It's sitting over there. And this is what they're learning. So it's good to know where the disconnect is between what citizens expect from their government and what they're actually producing, because they don't come right out and say it to you, because I don't know if they're stuck on the ignorance is bliss thing or what, but when I've talked to government officials and they admitted to me in person that the government owns all the land and thereby your house, because it's attached to the land, it's real property, real estate, um, which is heavily contradicted to what I think U.S. citizens believe, that if you pay hundreds of thousands of dollars for the land and the house, that it's yours. You have the right to exclude people from using it, and that used to include the government. That's why we had land patents. That was the first form of title that people got when they purchased land or discovered land and claimed it. Then they got it made in patent, and because they got a patent, they probably had to pay a fee for it. But either way, it was a one-time thing. There was no regenerating tax over and over revolving door until after the Civil War. So we had at least about 100-year stint of no property taxes, probably even a little longer, maybe another 20 years after that. And then suddenly things changed. And what I'm going to show you is what I've found just looking around on the internet real quick. How they perceived the land patents were, the exclusions it created, and why that was important to have. Because I feel like people are losing touch base of why it's important to own property, especially land, and how that's how the forefathers defeated feudalism with kings and queens, monarchs. They wouldn't let the government, being them, own all the land and then charge them fealty to use it. Alright, so without further ado, we're going to hop into it. I'm recording myself on OBS. Why, I don't know. I'm looking at myself, so here we go. Pop up the browser. Now this is my property book that I bought brand new, which gave me a code so I could access online, which is really nice to have. I recommend people doing this. As you can see, I got the full text is right up here. You can look at court cases, sidebar, opinion to it. Be very careful when you read through certain things, because there's stuff that's quoted, and then there's stuff that's just opinion by the author, and it may not actually mean what the case represents, or what you might interpret law to be. So just wanted to show you that real quick. That's kind of where I'm going at. I don't know, maybe I could show you this first part of the property book. Chapter 1 talks about acquiring property by discovery, which is land claim, and that's protected by, I thought it was Article 1, Section 8 of the United States Constitution. It's the same thing that made we'll just look it up real quick. The same thing that made the GPO or BLM, or I'm sorry, the UPTO. If that's even going to come up right. Probably not. It's the Patent and Trade Office. Maybe USPTO? USPTO? There we go. And we can go right to their website. They all they like to talk about is intellectual property now with the Patent and Trade Office, but it was created during the time that land patents were made available. So if they're the office that makes patents, then they must have been the one to authorize land patents. If I can get to the history, should have had this one up and ready to go. I don't want to do FAQs. Learning and resources, maybe? Patent trademark, maybe. Where's the history? Oh, maybe it's in About Us. Article 1, Section 8, Clause 8. Promote the progress of science, useful arts by securing in limited times to authors and inventors the exclusive right to the respecting writings and discoveries. Exclusive, meaning you have the right to exclude others from using what? Your discovery. That is the power of the patent. And that includes the government. There have been many lawsuits of excluding the government from trying to charge individuals for stuff that got patented. There's no fees on it. They can't put a fee onto it, especially a reoccurring fee. Once it's patented, it's legally yours and the highest title that the government respects. Okay, moving on. So I get these emails because I registered with Case Text, I think. And this is one that comes up. Okay, takings clause is what the government uses, or it's what we have to protect ourselves from the government from just taking our property, like civil asset forfeiture, stuff like that, without due process, and without, it being an excessive fine or fee. So this, if you think about it, property taxes, if they're constantly taking your money because of something that you supposedly own, they're creating a taking. And if you don't have due course in law to be able to correct that action or be able to challenge it, then it's violating the U.S. Constitution. Now here, this person talking about the takings Cedar Point case. Takings clause of the Fifth Amendment vindicates both property rights and the rule of law by prohibiting arbitrary, lawless state action. but the standard story linking property rights, legality, and constraint on arbitrary governance is more commonly stipulated than analyzed. Okay, and it talks about the case, Cedar Point Nursery versus Hasid. It doesn't go into details in this thing, but it's basically saying take a look at this case and scrutinize it a bit. The point I wanted to say about it, is to that end, it offers first a careful analysis of the sharp rupture that Cedar Point makes in takings jurisprudence. Jurisprudence just means like the way law is, or the purpose of law. Kind of like if it had an ethos behind it, that's what it would be, I would assume. Not only is the court's result difficult to explain in terms on traditional legal methods, it also destabilizes a previously predictable litigation landscape, and so engenders, which I don't know why they use that word, profound uncertainty on the ground. There is further no obvious way for the court to restore stability and predictability to the doctrine, so takings law will likely prompt confusion, not certainty, for the foreseeable future. Okay? So right here, this is an omission that there's a problem going on with the takings process in the courts, and it's getting scrutinized. Now, the General Land Office is what pre-existed before the Bureau of Land Management. The General Land Office, I guess, issued land patents, even though I don't know that they're an office that can make a patent. If there's a patent and trade office, I don't know that connection yet. Still looking for it. But I put this in the search right here. What government agency? I knew the answer, but I wanted to, again, find a direct thing. Sorry, my dog is having a nightmare. Wake up. And then I don't, it probably is issued by the GLO, but again, how can they create a patent if there's already a patent office? Is there a cross thing? Do they need a request to the patent office to be like, hey, we need a patent for this? I say okay, and send it to them, and then they stamp their name on it? I'm assuming that's how it goes. Because if so, then we can tie the constitutional right, that exclusive part of the Constitution, to a land patent saying discovery of land patent right in the Constitution. But underneath it, I saw this quick thing right here. What is a land patent? 9 things you should know from this land investment company called GOKCE Capital. And when you go in here, it pulls up this site. And there's some omissions here a little bit, but then it just totally doesn't talk about, for one, they think it started in the 1800s, that's funny. But land patents and land grants have been issued for a long time, like another almost 25 years before that. So they're talking about what it is. A legal document issued by the federal government grants an individual a title to land that was held by the government, not is held by the government. If the government can still hold the land as a possession of its own, then that makes it part owner. And then we need something to balance, well, how much ownership does the government still have over it versus me? And that's something that they never want to talk about. Let's see. Okay. These patents serve as early forms of title. They allow people to assert their ownership against all others. See? The right to exclude others. That included the government. That's why they couldn't tax you. The GLO became obsolete, got replaced by Bureau of Land Management. And that was, I forget when they did that. I'm sure it correlates pretty close to the Civil War. I don't remember. See if it mentions the allodial stuff. Government to individual land conveyances. Yes. I don't know why they act like these states, or the 13 colony states, didn't also issue land patents. Okay, it's not talking about it, I don't think. Yeah, but this goes into debunking the, property tax thing where no, they can still tax your property because they're not mentioning to you what the powers of their patents do. Their patents still keep all the rules and regulations against you. So all they need now is a statute, and they can defeat the U.S. Constitution with it, apparently. But they haven't ratified or changed the U.S. Constitution. Yeah. And most of the federal land patents now are just what they would call mineral rights, so you can drill for oil or whatever and all that. Especially in land that's not yet developed, it's way out in the wilderness. It's crazy. But here they're admitting that you can get free land still. You can just come and claim the land. It's not entirely free, but very cheap, I'm sure. She's going to help you find it. Even though I don't know what her stake is in all this. She says she talked to a whole bunch of real estate attorneys, but she's not one. Yet she makes this huge thing with multiple YouTube videos about it. So, talking about the homesteading from Abraham Lincoln's time and the last land claimed by this guy in Alaska in 74. But again, we're not talking about, okay, if it was a patent and it was a land patent and he was allowed to do whatever he wanted with the land, it's because it's not an area that needs to heavily tax the land to procure money for itself, or it's allowing him to go find the minerals for them so they can come and use eminent domain and take it away from him if he does find stuff, probably. So there's a million different ways this can go, but to think that you can't claim land, wrong. They were supposed to have this set up to where you could claim land that you find that's without residency or ownership, and pay the government a small fee, one-time fee. It's yours. You use it. You get it locked in under patent so you can exclude others, including the government, from using it. And now we're stuck with the stuff that we have right now. So I also found this from the Michigan State University, who talked about land patents. Just found it today. And again, they're debunking or they claim to be debunking the land patent stuff, but here they think that U.S. government acquired land in Michigan by winning the War of 1812. Okay, the only section of land that was in dispute at that time was Detroit. So that's ridiculous. There was already a territory of Michigan making laws, had a judge, Judge Woodward. It already had governors. I've already looked at the original law books up in the law library that predate this time. So to think that the government acquired the land at that time is absolutely false. They acquired it after they beat the British and got the treaty with them during the Revolutionary War. And I think that was the Treaty of Paris Treaty or whatever. And that land's already been like the federal government could still sell titles of the land to the inhabitants through federal land patents. And when the Michigan government became state, got its statehood, and got inducted into the United States government, they too were issuing land patents under their own government, which still exempted people from property tax. They didn't even have a property tax law at that time. So, uh, also the treaty we did with France, or the Louisiana Purchase, bought all that territory that's even further west than Michigan, um, before 1812, if I remember right. It may have been 1815. I might be off by a couple of years, but still, the land's already been uh, in Michigan's possession. It already had a government set up there, and they were selling land. I don't know. Unless maybe it just needs to be explained better to me, but it didn't inquire that the entire land of Michigan in 1812. That's way wrong. And then they say that the GLO survey created the township squares. This was already in the 1787 land ordinance by Thomas Jefferson to set the townships up this way. So when it got completed, I don't know. But to act like it all started after 1812, and that doesn't seem right at all. I think one of the precursors for Michigan to even get its statehood, the government of Michigan, the territory of Michigan, to become the state of Michigan, was that everything had to be surveyed, plotted out into counties and then townships. And then the townships were selling the land, or the counties, or whoever, or even the state, till everything was filled up. And then once they got everybody on a section of land, the U.S. Civil War came in, and then we lost our right to the taxes. And this is the Attorney General of like 1994, or I think, where's his name at? Yeah, Frank J. Kelly, Michigan Attorney General of 1994, was saying all this. And here's the General Property Tax Act here in Michigan from 1893, obviously after the Civil War, to where even this was saying, this specific one back in this time said the point of taxation was a point of transfer. When you sell land or transfer from one person to another, there was a tax accrued there, and that was paid. It didn't talk anything about a reoccurring property tax, even at that time. I think that came in later, around the 1940s. They keep rechanging the definition of the laws until it's, we got to pay for salaries now. We got to pay for these offices, which just constantly accrue, need for revenue. So we have to constantly charge you now. And this gets lumped into with like sales tax. So when you buy something, that's not a reoccurring tax. You don't have to keep paying the tax on a piece of property that you've already bought. Once you buy it, you buy it. You've paid for what the government needed to create regulating agencies to help produce that product safely to you. That's their excuse. That's already done. But when you buy a house or anything, you're paying interest and taxes on that already for a sales purchase, and then you're paying a reoccurring property tax for their offices and the salaries of these government officials to keep going, and they're holding a lien against your property the entire time to do that, but they don't have a physical record of this lien. And you won't be able to find one. I've looked in the records here locally. And I've looked through Bureau of Land Management too. There's nothing that says the government owns the land. In fact, they're not supposed to, because your money creates the government. Anything that's bought with the government with your money should technically be yours too. That's why it's called public. It's owned by all. So if you go to a public park, everybody has access to it because you all paid for it, one way or another. Um, and in here, this attorney general claims that the state um, immediately gave the land to the state of Michigan. Or there was some kind of, once they made a federal land patent, then it can be transferred into regulations and stuff, and then they can start taxing. It was such a strange, weird excuse. Here it is right here. Public property belonging to the U.S. exempt under taxation under this act. This exemption shall not apply if taxation of the property is specifically authorized by federal legislative authority, blah, blah, blah. And then they're claiming power under U.S. Constitution, Article 4, Section 3. And they say, Clause 2, over property to which it has title. So now we're saying the government has property it has title to? And this is all about general property. This is about land. And that, however, nothing in that provision governs the regulation or taxation of property after it no longer belongs to the U.S., i.e., after it's conveyed to others. So, after the federal government stopped issuing their land patents and allowed the states just to take over to do what they want to do, states are free to do whatever they want. That's how they're stating it. So now we're going to look at this Article 4, Section 3, Clause 2, to where they say federal government conveys property, and then once it's done conveying, states can do whatever they want, right? So this is nationalarchives.gov. This is the official website for the U.S. Constitution. And just show you, this is okay, the transcript of the Constitution of the U.S. Article 4, Section 3, Clause 2. Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the U.S., and nothing in this Constitution shall be so construed as to prejudice any claims of the United States or of any particular state. Now, the Attorney General just said that this gives them, they didn't just say, they said it back in 94, that this basically gives them carte blanche to make any rules or regulations. It's in the Constitution. They got their power from there. The Constitution has many things involved in it. That it has to respect other parts of the Constitution to exist too, right? So, if the Constitution was set up to where the government cannot take from you without giving you just compensation, due process of law, without excessive fines or fees or cruel and unusual punishment, blah, 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 that there must be an inherent right to the property itself that you have. And when they created the Patent and Trade Office and cited the Constitution as well, with the discoveries of land and whatnot, they made a patent which allowed you to exclude others from the use. That prevented the government from doing property taxation. Ergo, you must have a right to own property and to be able to keep the government from using it to procure its own revenue and power. Okay? They got to be called out for this stuff, because if they're not, they're just going to keep like a runaway train taking all the rights away. I mean, you're already living in a socialist state right now, face it or not. Your constitution dissolving day by day. So if you don't start fighting for it, consider it gone. So, what do you think that they were actually trying to say in this clause? Congress shall have power to dispose of and make any needful rules and regulations respecting territory or other property belonging to the U.S. Okay, what is property of the U.S., meaning the federal government? If it's the land, they have the power to dispose of it. They have the power to get rid of it. They have the power to sell it. And then they can make any needful rules and regulations, for the area or whatever property it need be. There's federal statutes all over. You got your federal rules for the borders, customs, national parks, stuff like that, What the Native Americans are allowed to do on their land, that's their reservations, depending on what kind of treaty or agreement they have with whatever respective government. So, sure, they have the power to make the rules and regulations, but they cannot violate the United States Constitution. That's, I think, Article 6. Yeah, right here. Article 6, Section 2. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the U.S., shall be the supreme law of the land. Okay? This Constitution, we're just shortening it up. Supreme law of the land. There's nothing higher. No judicial officer, no statute drafted by some lawmakers. This Constitution, supreme law. And the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. See? Even the constitutions of the states cannot go against the Constitution of the U.S. Alright? That's the biggest one. All of your arguments should come back to this if you want to maintain your constitutional rights. And everybody's trying to get rid of the federal government and just have state governments, or a lot of people are. If you do that, your United States Constitution's gone. That's part of the federal government. That's the U.S. citizenship contract. Constitution, federal statutes. That's what you owe the federal government. State government, state constitution, state statutes. That's your state citizenship contract. Okay? If you get rid of this one, and the states no longer have to abide by the federal one, you're going to lose everything. And that's one of the main reasons why the federal government was created in the first place, was to be the bigger, more expensive bully than all the states, to keep everybody on one standard. But as soon as they let go and stop doing something, the states just run with it, just like that Attorney General from Michigan stated here. And is acting like they have carte blanche to do whatever. And I'll have to look through some of these cases that the Supreme Court citing. But just because a case is cited doesn't mean we're looking at all the you hardly ever get to see the evidence that was submitted in the cases. A lot of it's opinion, a lot of it's kind of downtrodden stuff. I think we don't have a good discussion about law in this country. We just see people's wins and failures, and we're letting a system continue that is depriving us of our rights more and more. We are not getting them back. And it needs to stop. Or else we might as well just let Russia into our gates, because the U.S. government's not doing what it's supposed to do. We're going to become a communist nation anyways, one way or another, if we don't stop. That's all I got. You guys take care so I can get back to my case.